Hello, how is everyone? Good to see you all. Nobody expected this, did we? And you can see I added Mo in as a mod. So we will I'm going to start at the top. Oh, let me. Now, if I take myself off, will you still hear me? Hold on. Okay, sorry about that. Sorry. Well, hi, Mel. Okay, this is an order unsealing records. Based on the parties' lack of objections and the fact that none of the factors listed under ICAR 32 warrant continued sealing of the material, the county hereby orders the unsealing of the following records identified in the court's August 4th, 2025 order regarding sealed documents. 1, 3, 6, 13, 14, 15, 16, 21, 22, 23, 24, 28, 32, 36, and 37. Ordered and dated and signed by Judge Hippler. That's a lot of documents, isn't it? Is the volume okay? I hope so. Okay, this one is order maintaining sealed status. The court finds that the sealed status of the following records identified in the court's August 4th, 2025 order regarding sealed documents shall remain in effect for 9, 18, 25, 26, 27, 30, 31, 35, and 40. Item 9 must remain sealed as it is replete with identifying information of the proffered alternate perpetrators, the unsealing of which would contravene the privacy concerns of these individuals and likely subject them to unwarranted harassment and reputational harm. Thus, continued sealing is warranted pursuant to ICAR 32, and you see all the numbers and letters. The remaining identified records all relate to an ongoing and statutorily confidential investigation into potential leaks in this case and are exempt from disclosure. And again, it's signed and dated by Judge Hippler. Nightbot, you just calm it. What did Monty do to you? Nothing. Oh, I don't know what to do with it. Eric, you're going to have to tell me. I've done all I can do. Okay, the next one is order unsealing and redacting records. The following documents identified in the court's August 4th, 2025 order regarding sealed documents objected to at least in part by one or both parties are to be unsealed, though several with redactions. Items 2, 4, 7, 10, 12, 19, 20, 33, 34, 38, 39, 42, and 43. The basis for unsealing and redacting are as follows. Orders modifying, amending no contact order. There is no further justification to warrant the continued sealing of these orders. However, the court orders that the date of birth of the defendant and of the protected persons be redacted. I can understand that. Exhibits S1 to state's response to defendant's 24th supplemental request for discovery. The name of the individual identified within these documents has already been widely disseminated by the media. Thus, there is no justification to warrant the continued shielding of her name. However, the court orders that the individual's date of birth be redacted. In addition to the state's assigned AV and Bates numbers identifying the location of the discovery is not protected work product as contemplated and therefore will not be redacted. Notice of filing defendant's additions, objections of the jury questionnaire. There is nothing in this record that justifies continued sealing. Completed juror questionnaires are confidential to protect juror privacy, but that is not implicated in this record. Consequently, it shall be unsealed without redactions. Exhibit to defendant's 24th, Exhibit W to defendant's 24th supplemental request for discovery. The name of the individual identified within these documents has already been widely disseminated by the media. Thus, there is no justification to warrant the continued sealing of her name. However, the court orders that the individual's date of birth be redacted, which I think we can all agree on. 6/18/25. Court minutes for closed session regarding motion concerning alternate perpetrators. Although there is no longer a justification to warrant the continued sealing of the entire document, there were discussions recorded within the minutes that require protection. First, the minutes at 1:32:52 refer to identifying information of the proffered alternate perpetrators, the revealing of which would contravene the privacy concerns of these individuals and likely subject them to undue harassment. Thus, this reference will be redacted. Second, the minutes starting at 1:36:17 through 2 0705 documented discussions regarding the status of an ongoing investigation into a potential leak in this case. This information is exempt from disclosure under, of course, the rules and laws, and therefore shall be redacted. Defendant's reply to state's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrator. That was a mouthful. There is no further justification to warrant the continued sealing of this filing. However, in the interest of privacy and to guard against likely harassment, the court orders that the names of the proffered alternate perpetrators and other identifying information be redacted. You got to stop and remember, he pled guilty, so there's no need for anybody to know who these people are, in my opinion. The state's motion to amend witness list and supplement expert disclosure. There is no further justification to warrant the continued sealing of this filing. The name of the retained expert witness identified in this filing was previously revealed publicly in this case, and the unsealing of the document with the expert's name is unlikely to result in undue harassment. Consequently, it shall be unsealed without redactions. Order granting defense experts analysis of evidence. Although there is no longer a justification to warrant the continued sealing of the entire order, the court orders the identifying information, name and address of the expert identified within be redacted until such time the court has heard from the parties regarding the privacy concerns related to the individual and makes a determination whether to further unseal the documents. State's response regarding defendant's motion for independent analysis of evidence. There is no longer start over. There is no okay. They got it wrong. There is no longer a justification to warrant continued sealing of the filing. The sole objection was the revealing of the expert's name and address, but this information is not included in the filing. Consequently, it shall be unsealed without redactions. Motion for independent analysis of evidence. See number 33, supra. So we've already went over 33. State's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrators. There is no further justification to warrant the continued sealing of this filing. However, in the interest of privacy and to guard against potential harassment, the court orders that the names and other information that could be used to identify the proffered alternate perpetrators be redacted. The unsealing of this filing, however, does not extend to the appended table of contents listing the state's exhibit to the filing, nor does it apply to the exhibits themselves, both of which shall remain sealed. I need a drink, so hold on. Sorry about that. Okay, Exhibit S1 to state's response to defendant's 23rd supplemental request for discovery. There is no further justification to warrant the continued sealing of this filing. In addition, the redactions requested by the state will not be made. The state's assigned AV and Bates numbers identifying the location of the discovery is not protected work product as contemplated. Further, the release of the names of law enforcement officers and experts disclosed as testifying witnesses in the case do not implicate privacy concerns sufficient to warrant redaction. Thus, this filing shall be unsealed without redactions. Exhibit B, defendant's 23rd, or V, sorry, defendant's 23rd supplemental request for discovery. This item will be unsealed consistent with the court's ruling related to item number 42. And of course, you can see it's signed and dated. How is everyone? Oh, you're all right, Fancy. I didn't expect a bunch of people. I was just going to read. What's going on, Gracie? Okay, well, you're welcome. I'll just continue on reading. You guys just hello, kitty. You guys just keep talking amongst yourself. Okay. I've started at the top and I'm working down and stuff, so we have many to get through. I may not get through them all, so just a heads up. I may drop the link for you to finish reading yourself if you want to. This is second order seeking parties' position regarding sealed documents. And this just goes through and lists all the sealed documents. I'm not going to sit here and read all this. It's got defendant's trial brief, state's trial brief. I mean, there's all kinds of stuff in here. Defendant's phase 1 lay witness list. Court minutes sealed. Mitigation witness list. So you can see that goes through quite a bit. Okay, let me make sure I'm at. There's nothing on further down. Okay. Sorry. I'll start at the bottom on these. This is from June 6th, 2025. It's going to be the motion to seal defendant's motion and order for emergency order. Oh, yes. Nightbot likes to misbehave. So let me get that pulled up so I can share it. It's not very long. Yeah, don't worry about Nightbot. We'll get it figured out. This is the motion to seal defendant's motion and order for emergency order. So I don't know. It was read, so I'm figuring this is something they unsealed. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves the court for an order to seal defendant's motion and order for emergency order. This motion is made pursuant to ICAR 32 I and C I.C. and all that, because the motion and order contains confidential information. And that's all it is. But it was read, so I don't want anybody to say I didn't read them all. Okay, this is a stipulated motion to the admission of additional evidence as evidence at trial. Oh lordy, this is 13 pages. Yeah, we ain't gonna get through all these because I don't plan to keep you all that long. This is submits to the court a stipulation to the defense's admission of 2 additional exhibits described for the record. Oh my, this is laboratory reports. Hold on. This is for trace, hairs, and fibers. This document may contain privileged and or personal identifiable information, including information related to juveniles and other protected individuals. This document must be afforded the protection required by applicable law, regulation, and policy. If you are not the intended recipient, we know all that. You're supposed to destroy. So it lists that they took hair samples from Ethan, debris from his right hand, hair sample from Kaylee, hair sample from Xana, debris from Xana's left hand, debris from the body bag, hair samples from Maddie, a necklace from Ethan, a bracelet from Ethan. Oh, wow. Earrings for Kaylee, fake eyelashes for Maddie, ring from Maddie, another ring, and another ring from Maddie, a hair tie from Maddie, the comforter. Oh, wow. The debris from the northwest bedroom on the second floor, debris from near northwest bedroom on second floor, debris from the hallway leading to the northwest bedroom on the second floor, debris from door of northwest bedroom on second floor. Debris from drying carpet. Debris from under computer pad on the desk in bedroom. That's his apartment. 1630 Northeast Valley Road. Yeah, that's his apartment. Debris from under the computer pad on his desk in his bedroom. Again. Debris from pillow in bedroom. Debris from east wall of the shower in the bedroom. And debris from broom head. And like I said, these are from his apartment. Left sock from Ethan, right sock. Left handbag. A shirt from Kaylee. Left sock from Kaylee. Left handbag from Kaylee. You see what that says from Xana. Oh, wow. Wow, 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 wow. Do I keep reading those? I don't know. Yeah, these poor kids. Left handbag, right handbag. Left foot bag from Xana. Shirt from Maddie. Left and right handbags. They did take a dog hair sample from Murphy. And then they got hair samples from the monster. They took a blanket. And the original package for a comforter. Filter from a dryer. And the catch paper from a dryer. Security tag from a dryer. Oh my. And they did take the vacuum from his apartment. The results of the trace evidence examination, hair and fibers, are included in this report. Sorry. I'm not going to read any more of that one. Sorry. That's the stipulated. There's just so many. Yeah, I can't read your handwriting, Hippler. Oh my. I'll show you this. It's hard to make it out because it's got Hippler's handwriting on it. And this is to do with additional exhibits as evidence at trial. It's ordered that the defense shall be allowed to admit 2 additional exhibits as evidence at trial. but evidence will not be yeah. Can anybody else make that out? I Avis, I have no idea. Yeah, he does write like a doctor. Here, I'll take myself off for a minute and make it bigger, and you can look at it. But basically, it was denied, so he's not allowing them to do something other than he didn't allow them to bring in the evidence, the additional. That one was just weird. That one was hard to read. And this one isn't. Evidence will not be admitted until offered with the appropriate witnesses. Thank you, Avis. See, I used to be able to read, doctor. I done it for over 10 years and now I can't make it out. But thank you, Avis. And this is motion to seal defendant's motion for access and objection to court's order. It's not very long. And that's just from him. Yeah. He moves the court for an order to seal the defendant's motion for access and their objection to the court's order. That was not long. Notice the filing of amended exhibit chart. Yes, reading the kids' handwriting probably does help. I agree with that. Like I said, I used to be able to read doctors' handwriting like no other. Sometimes I had to turn it sideways or turn it. We have one physician, I had to turn it totally upside down until it's slightly to the right, and I was able to make it out what it said. Go figure. Submits to the court his amended exhibit chart. The defense will provide electronic copies via Dropbox. And it contains their amended exhibit chart and additional exhibits. The amended exhibit chart contains the addition of defense exhibits D 1062 through D 1085. The defense is making the following amendments to exhibits. Adjusting, D204, adjusting exhibit number format so it is on one line instead of two. D447, removing pages bait stamped and through these numbers as they relate to Officer Nunez and not Detective Payne. So look, she was making some mistakes. D448, we are not able to put an exhibit sticker on these documents. This exhibit is bait stamped and gives the range. D856, providing a redacted copy. D946, correcting the exhibit number on the sticker. And D1021, adding an exhibit sticker. So, haha, See, she made mistakes as well. And that is absolutely nothing. But, yeah, what say you? I don't have the trifocals anymore. I couldn't do it. I went down to bifocals, but I can't use them to see a computer. Oh no, Mo. Here, I am going to give you the link here. And anything that you see, yeah, they are still keeping some things redacted, and some things they are unsealing. If somebody could open that and see if it takes you to the website, you can read them all for yourself. That one I just did not feel comfortable reading. You know, Mo, I don't know when we'll hear about the other stuff that we watched about with Judge Megan Marshall. Oh, do you mean that Open Davis? I hope that's what you meant. Oh, good. Good, good. Just anything that has a red little thing next to it and says new, those are the ones that they went through and partially kept redacted or just fully unsealed them. But you can read them at your leisure. I can't read some of them. I just, especially the one I was on. There's one in here. It's a guilty plea advisory. What day is that on? 7/2 of 25. And it's 9 pages long, and it's his statement of constitutional rights. So it does list conditions he says he has. What have you been promised? 4 fixed life sentences, consecutive and without the potential for parole, as well as 10 years, is what he wrote. So he, line 46, do you want your attorney to take any further action in this case? No. He marked no. Huh. So, yeah. Avis, the other things is video and photos that the families of Maddie and Ethan don't want released, but they've already released some. Yeah, Mo, I seen that. And I did cover that hearing, Avis, when they had it. I have to figure out how to get to her site on the Idaho site and see if there's anything posted yet as a decision or not. I can see her granting it, but then again, like they said, things are already out there, but I don't know. She just seems so sympathetic about what the families are going through. So, what did I think about today's trial? I personally feel defense is purposely throwing wrenches. You got it, Jennifer. That's her way of stalling and not wanting to go through any further. Okay, thank you, Avis. Right, that is a great summarization of it. You go, Donna. But yeah, those are out there. If you want to read them, there it is again, just in case. But at least we know they have unsealed some things. I'm sorry about the lighting. This is an old bedroom. So, and it's the only light. Me too, Jennifer. That judge for Donna, Judge Everett, he's no nonsense. He ain't having it. Yes, she does. That's exactly it, Avis. She's always been in control of everything. And she's trying to control things. Yeah. All right. There's people leaving, so I will let you be. You can all read those. Thank you for joining in. I read you some highlights, and you can go see what you can read and find out through the unsealing of some records. I'm going to go eat. All right. I will talk to you guys later. All right. Bye.